So today's presentation will look at the interaction of IP law and space law. A few housekeeping matters. If you could write any questions that you have in the Q&A, and I'll hopefully answer them at the end of the presentation. I've also got a construction site next door to me at home, so there may be a few crashes and bangs, and we're also expecting a storm in Perth in the next hour. So all things going to plan, we shouldn't have any issues, but there may be a bit of background noise from my end. So, oh, hang on. Okay, so today's session will cover, really it will more provide an overview, I guess, of the interaction between IP law and space law, and it's not going to go into any specific detail over one particular area. And there are a few reasons for this, but mostly it's more of an 101 introduction, just because there's so many different aspects that I'll cover. And if there's anyone has any specific questions into any particular area of interest, just let me know and I can obviously have questions and answers at the end. Sorry, I'm having trouble moving the slides. Okay, so why do we need to look at this particular interaction? Well, until recently, and by recently I mean, up until about 10, 15-ish years ago, a lot of space-based exploration, space activities were carried out and administered by state-owned organisations. So, NASA, I guess, being the one that most people would be familiar with. However, there's been a sort of transition from state-owned entities and organisations towards private industry carrying out, space-related exploration, for example. So there's obviously this transition means that the intellectual property of the technologies and the R&D and everything else that goes with these private industries obviously becomes of value and of importance. So as an example, SpaceX, which everyone should know is Elon Musk's space adventure, Blue Origin, as well as another company called Dynetics. They've recently, and that was as of last week, have been shortlisted by NASA as the private entities who will carry astronauts back to the moon as part of the Artemis mission. So they're aiming to return astronauts back to the moon in 2024. So clearly there's quite a lot of financial investment now going in this area. There's also been sprouting of many new different companies in relation to space-based activities. So there's a lot of satellite and CubeSat sort of satellite technologies for Internet of Things. There's a lot of companies who are now starting in relation to space mining, and I'll get into that a little bit more detail later on. And there's also companies such as Made in Space, which are, as the name suggests, looking to manufacture in space. And there's certain advantages of manufacturing in space that is provided over manufacturing on Earth. So IP laws and things such as patents, trademarks, designs, they all operate within some form of jurisdictional limit. We know, okay, the continental shelf or, the boundary at which Australia's jurisdiction, for example, ends and where international, sea begins is sort of quite well known. It also provides a monopoly, and obviously depending on the type of IP, that monopoly could be limited. So in examples of patents, for example, that would be a 20-year term, and that excludes others from using that particular IP. So it really provides the rights holder an avenue to exclude others from operating in that particular space. And IP laws, generally speaking, were established well before space exploration really ever took off. So space law is a collection of numerous treaties and agreements. It started around the early to mid, 50s, but it wasn't until the mid to late 60s that the Outer Space Treaty was established. And the Outer Space Treaty provides the framework from which all space law kind of has built from. The interesting thing to note, is that the Outer Space Treaty came into effect during probably what was considered the height of the Cold War. And the design and purpose of it was to ensure that no one nation could lay claim to anything in relation to space. You know, given the political environment at the time, it was essentially to try and stop the US or Russia, or both, I guess, try and have some form of advantage in space. So international law, which includes the charters of the United Nations, applies to outer space and celestial bodies. And as I said, it essentially establishes that no one nation can claim ownership of any space or celestial body. So there's a bit of a dichotomy here in that IP laws provide a right to the rights holder for the exclusion of all others, whereas space law provides a right for everybody at the exclusion of one particular entity. So does this dichotomy change the way that we need to view IP laws and IP strategies when looking to protect space-related technology? So I guess the first thing you need to ask is, well, where does space actually start? So this is actually an area that is still contested today. So in the US, for example, if you're above an altitude of about 80 kilometers, you're considered an astronaut. The general, and I use the word general loosely, consensus for where space begins, is the Kármán line, and that's at an altitude of 100 kilometers. So the Kármán line is the line at which a plane, so, you know, just imagine a jumbo jet, for example, in order to drive enough aeronautical lift, they'd have to be traveling at a speed fast enough for them to escape velocity. So basically, if you're a plane trying to fly at the Kármán line, you will actually just end up flying out into space. So that's where, from, I guess, a technical standpoint, they've tried to delineate the boundary of space. This 100-kilometer altitude is still actually being debated, and towards the end of last year, there was some form of discussion about whether that altitude needs to be revised down to a lower altitude, and I think it was about to around 80 kilometers. Again, I think this was from a push from the US. But, you know, as broadly speaking, you can kind of consider around the 100-kilometer altitude as the beginnings of space. So why does this actually matter? Well, the Patents, Designs and Trademarks Act all define that those respective acts extend to the airspace above Australia. So presumably, if it's only extends to the airspace, at some point the airspace will end and then space will begin. I guess trademarks are a little bit different in that they have a somewhat grey boundary because you can obviously target consumers across a jurisdiction. So you think about advertising online, for example, and this potentially has implications for advertising in space, and I'll touch this subject a little bit later on. So the Patents Act don't really define, the Patents, Trademarks and Designs Acts don't define where space begins. So where would you actually look? Well, trespass from a property law standpoint occurs at a height that is necessary for the ordinary use and enjoyment of an occupier. I think looking towards property law in respect to figuring out where space begins for, you know, the Patents Act, for example, probably won't provide much guidance, purely because, I mean, you think about drone technologies and what would be a ordinary use and enjoyment of one occupier for one particular type of technology may be completely different for another. So the Air Services Act and the Civil Aviation Act, they also don't define airspace, but they do define what an aircraft is, and that is any machine or craft that can derive support in the atmosphere from reactions with the air. So put simply, can it derive lift from passing through an atmosphere? Again, I guess this somewhat defines what space is in the negative. But probably the most clarifying definition is from the Space Launches and Return Act, which came to roll ascent late last year. And that actually defines what a space object is. And that is essentially something or an object that travels a distance beyond 100 kilometres above mean sea level. So if you're a space object, I guess by definition, you're probably in space. So on the face of it, at least, I think that the Space Launches and Returns Act provides some form of guidance as to the fact that for designs, patents and trademark acts, the airspace defined within those acts extends to 100 kilometres above mean sea level. So above that distance, you're then in space. So I'll just quickly talk about the Outer Space Treaty. So the Outer Space Treaty has numerous articles. There's quite a few in there. The ones that are probably most relevant for in terms of IP would be Articles 2, 6, 7, and 8. So as I said previously, the Outer Space Treaty, or space law, essentially says that no one nation can claim to any area of space or any celestial body, and that's really defined in Article 2. Article 6 defines that in order for you to do, for any entity, so that would be government or non-government entities, to do any form of space-related activity, so send a rocket up to the moon, for example, you have to have some form of authorization from the government to do so, or that particular nation or jurisdiction. So Article 7 defines the responsibility. So each state, so for example, if you had an Australian company, that would be an Australian state that launches or procures the launching of an object into space, is ultimately liable for any damages to any other state party. So for example, if I launched a satellite up into space and it crashed into a satellite that was part of under US jurisdiction, I would ultimately be responsible, and by extension, the Australian government. There are provisions, I guess, to minimise to some extent the exposure of the government and push it back more onto the private entity, and I'll talk a little bit more about that in detail later on. So I think ultimately, Article 8, and this deals with objects that are launched into space. I think Article 8 is probably the most relevant in terms of the interaction of space law and IP laws. So the state on whose registry of an object is carried retains jurisdiction and control of that object. So if an Australian company registers their space object in Australia, then the jurisdiction of Australia extends to that object even when it's in space. Now, where this gets a little bit complicated is the fact that the registration comes under the Convention of the Registration of Objects Launched into Space, and it defines the launching state as either a state who procures or launches the launching of a space object, or a state from whose territory or facility a space object is launched. So there's two, I guess, subtle changes there, but they actually have a bit of a profound impact in relation to to IP and how that extends into space. So I've just given a few examples, and I'll then talk about how you would look to work out which jurisdiction is involved in each particular scenario, and then how, I guess, ultimately that would relate to infringement. So scenario 1, you have, company A, they have a patent for a rocket engine. Company B manufactures and sells the patented rocket engine without authority from A. Scenario 2, you have company A, they have a patent for a method of operating a rocket engine. Company B manufactures the rocket engine and knows that in use it will infringe company A's patent, but they sell it to company C. Company C operates, a spaceship that uses the patented method without authority from A. So obviously, scenario 1 is probably a little bit simple. Are A and B in the same jurisdiction? Is there direct infringement or not? Scenario 2, you have 3 separate parties. Again, you might have 3 separate jurisdictions. There's also, I guess, contributory and direct infringements to consider. So scenario 3 is you have company A, they have a patent for a method of operating a particular apparatus. So let's just say a satellite, for example. Company B sends the apparatus into space, but then company C operates that object using the patented method from company A without their authority. And scenario 4, I guess, is company A, they have a patent for a method of building a rocket engine using a 3D printer. Company B sends a 3D printer to a manufacturing facility that is located in space, and company C builds a rocket engine using the patented method. Now, scenario 4 may seem a little bit far-flung, but this is actually sort of starting to happen now, not necessarily with respect to rocket engines, but as I said at the beginning of the presentation, companies such as Made in Space are looking to manufacture particular items in space now. So it all comes down to where's the jurisdiction of which jurisdiction are each party in. So Article 8, means that the IP law of whatever state that object is registered in extends to that space object. So if you have a rocket that you want to send to Venus and that rocket's registered in Australia, Australia jurisdiction extends to that rocket and personnel on that rocket. The problem is that the Outer Space Treaty didn't account for any of the formalities of registration. So there's the potential for a flag of convenience problems, and this is experienced in maritime law. So, you think how many ships are registered in, countries such as Panama, Marshall Islands, Liberia, and they do that for their, various reasons. So what you need to do is, even if the jurisdiction extends into space, is that the same as the jurisdiction of an alleged infringer? And to work that out, you have to look at the control points of all the parties involved. So example one is, say, ACOM Corp, they're based in the US, but is duly licensed by the UK to set up a launch facility in the Turks and Caicos. Now, for those that don't know, the Turks and Caicos is an British overseas territory. So UK law kind of gets imparted into Turks and Caicos. So ACOM Corp launches a satellite from a launch facility in Turks and Caicos, and so that would carry the registry of UK in accordance with the registration convention. So even if some control of that object is in the US, but the primary control is in the Turks and Caicos, the UK would still have jurisdiction over that particular object or satellite in this instance. So if ACOM Corp were to infringe or arguably infringe a US patent, the US courts would have no jurisdiction because the infringement in principle never happened in the US. So example two, ACOM Corp, they launched a satellite from Turks and Caicos, similar to before, but now the primary control is in the US and not Turks and Caicos. Because it was ACOM Corp launched it from Turks and Caicos, UK is still the state of registry. So similar to before, ACOM Corp wouldn't infringe any US patent because the US law the US has no jurisdiction over that satellite. Well, what about example three, which is a little bit more complicated? So ACOM Corp, they're incorporated in the US, but then they set up a subsidiary, a wholly owned subsidiary, we'll call it ACOM Sub, and they're incorporated in the Turks and Caicos. So ACOM Sub, they purchase a satellite from a US company and they procure the launching services from a facility in the US, but they still control it from the US. Because ACOM Sub is incorporated in Turks and Caicos, UK steps into the shoes of ACOM Sub again, as with the previous two examples, and is deemed to be the launching state. So again, the US courts wouldn't have jurisdiction if ACOM Sub infringed some US patent, for example. So you can see how the jurisdiction from under which governs or controls a particular object in space really depends on commercial decisions that happen, well before any IP may be generated. And it can also technically be used as a way to avoid any patent rights. So if you have a fierce competitor, they may say, well, I'm going to do an ACOM Sub sort of situation, incorporate in another jurisdiction, and so every action I do in space is under a different jurisdiction, so I avoid all your patented rights, for example. So if you go back to those four scenarios as I was talking about before, you really just have to look at how each company is operating and in which jurisdiction, and which jurisdiction extends to the rights holder and to the alleged infringement the alleged infringing activity. So for scenario one, most people would see that, and especially if it occurred on Earth, as a typical direct infringement type scenario. Scenario two is kind of similar. If that occurred on Earth, that would be, you've got a party who may be liable for contributory infringement, and then another party who arguably is liable for direct infringement. Scenario 3, that's where it starts to get a bit more complicated, because you've got 3 different parties: 1 who makes the satellite, 2 who's sending a satellite into space, and 3, 1 who's operating. If A and C in scenario 3 are in different jurisdictions, then arguably C isn't infringing the rights of company A. And similarly for scenario 4, if company A has a patent for that particular technology and it's in the same jurisdiction as the manufacturing facility, then C would arguably infringe company A. But if that manufacturing facility is different, or the jurisdiction, sorry, of that manufacturing facility is different to what company A is, then company C wouldn't infringe any patent rights of company A. Scenario 4 can also get further complicated just due to the fact that certain sections of a space object may be registered in different jurisdictions. So if you use the International Space Station as an example, so that's ultimately administered through NASA, but there are several different modules that are associated with different separate countries. So the Japanese module, in principle, comes under Japanese law. The Canadian module comes under Canadian law. The US module under US law, and so on. So even within a single facility or facility in space, there could still be issues of infringing rights by going across jurisdictional lines. Whether this actually happens in practice is another story, but the mechanisms are in place for this to be an issue. So, I've been talking about these issues, I guess, from an Australian perspective. They still apply equally, around the world. But, in terms of our Patents, Designs and Trademarks Acts, for example, defining what an airspace is, that's obviously from a very Australian-centric perspective. So what happens elsewhere? Well, in the early 90s, I guess the US kind of foresaw some of these potential issues, and they amended or introduced a certain Section 105 in their Patents Act that makes it clear that any invention that's made, used or sold on any space object that's registered in the US, actually it falls under US law, with the exception being if that space object is registered in another jurisdiction. I don't think this provides any further, I wouldn't say guidance necessarily on this particular issue, but it does, to some extent, sort of make it clear that, at least in the instances of the US, this is how it occurs, because ultimately this mechanism happens due to the way the Outer Space Treaty has come in effect. So Germany, they introduced, I guess, a similar section to their Patents Act in relation to joining the European Space Agency, but to the best of my knowledge, no other jurisdiction has an equivalent section in the respective laws. And as I said, I don't know if it actually would provide any further guidance, because ultimately, if you adhere to the Outer Space Treaty, the conclusion from which is stated in Section 105, for example, in the US Patents Act, still applies elsewhere. So, I've talked about how the jurisdiction extends into space. So let's just say, hypothetically, there is some form of infringing activities and the alleged infringer is in the same jurisdiction as the I rights holder. How do you actually even prove infringement in space? You think about the logistics of trying to figure out and at least view an infringing activity. For a method of operating or doing a particular activity in space, let's just say operating a robot on the moon, for example, for space mining, presumably, and at least at this point in time where we are with the technology as it stands, there would be some form of connection back to Earth. So there's probably some form of control mechanisms in place, which you could at least look to as evidence in relation to infringement. So ultimately, I think discovery and things like that will become more prevalent in relation to working out infringement for space-related technology. I mean, you think about importation of, a particular device, for example, you can actually physically touch it and feel it and say, well, yes, this is the same, and I can see this operating in the exact same way as, whatever may be protected by a patent, for example, but that's not necessarily the case in space. I guess the other thing is even if you can prove infringement, what about how do you enforce your rights? If we take the example where you set up an ACOM subtype scenario, let's just say you have a fierce competitor and they set up in Nigeria, for example, if they're doing that purely as a way to circumvent or get around some form of patent family or patent registered rights or whatever it may be, is there a way to challenge that registration in Nigeria and force it back to another country, such as Australia, for example? In practice, not really. Partly that's because registering an object for the purposes of space travel and the like is quite a logistically complex process, and I'll sort of touch on that a little bit later on. So I'll talk briefly about space mining. Now, this has sort of been an area that's, I think, has received more interest in the last, say, 2 years. There are various reasons for this, but space mining itself has got a bit of a problem. The main one being is Article 2 of the Outer Space Treaty says that no one can own a celestial body. So the argument or the issue is whether that extends to the resources themselves that are extracted from these bodies. So the US and Luxembourg, they have adopted the position that extracting resources does not count as national appropriation, and they've actually gone on to enact their own laws specific about space mining, making it clear that yes, the private company could go and mine the moon, and that's perfectly legal. The UAE, it looks like they're going to enact similar laws maybe sometime this year, maybe next year, although that timing may be put on hold given the current COVID environment. And President Trump, at the beginning of April, so about just under 4 weeks ago, signed an executive order that basically clarifies the US's position that, yes, space mining is something that is legal. But in order to do so, it was interesting that he said that it would require a lot of collaboration. So, you think about, okay, well, company in the US, maybe company in Australia, company somewhere else, all banding together to try and perform these space mining activities. Now, as part of space law, there's the Moon Agreement. So this is separate to the Outer Space Treaty. And the Moon Agreement basically says that minerals and outer space resources can be used for scientific purposes and to support scientific missions, but that when space mining is about to become feasible, the parties who are signatories to the Moon Agreement need to come up with some form of appropriate international regime. Now, there's only, I think it's about 18 countries that have actually signed up to the Moon Agreement, Australia being one of them. Most other spacefaring nations disagree with the principles of the Moon Agreement, and they say that the Outer Space Treaty is the relevant law and that the Moon Agreement plays no part. And so President Trump's executive order kind of just sort of clarified that point, saying we're going to disregard the Moon Agreement and proceed as outlined. Look, the issues with the Moon Agreement and whether space mining is legal or not is a huge area of contention, and I guess there's a wealth of knowledge and opinions and literature on this particular area. So I won't go into any more detail on it, apart from why is space mining important? Well, there's been found that there's ice on the moon. You can convert ice into hydrogen and water with electrolysis. In principle, that means you have a resource that could act as a fuel station for further space exploration. And this is something that Blue Origin is looking at doing. Asteroid mining has the potential to unlock vast amounts of minerals, metals, gases, and other rare earth elements. So Psyche 16 Psyche, for example, is an asteroid in our asteroid belt in our solar system. It has a diameter of about 200 kilometers, give or take, and is essentially a solid chunk of iron, cobalt, and nickel, with an estimated value in the trillions and trillions and trillions of dollars. So there are financial reasons and drivers why people would start to look at space mining. The other thing as well, if you are starting to do off-Earth manufacturing, at a manufacturing facility in space, you're going to need resources. Sending resources from Earth up is probably prohibitively expensive, which is why space mining is quite attractive. So obviously I've been talking about a space-related technology, so it's more in relation to patents and I guess to a lesser extent designs. But what about trademarks? Well, how does targeting clients or consumers across jurisdictions works? So for patents and trade designs, infringement needs to occur in a jurisdiction. This is still also true for trademarks, but you can have infringement across jurisdictional lines. So if you think about .com versus .com.au advertising issues, you have a company based in the US and is controlled in the US, but they're advertising to Australian consumers. Is that targeted targeting of the particular trademarks or not? So if you think about this in terms of infringement in space, if you had a space hotel, for example, and let's just say it's registered in the US, you then have various parties sending up spaceships to have tourists go to the space hotel. If the outsides of those spaceships are covered in advertising, if those spaceships are registered in a jurisdiction outside of the US, then in principle you have that targeting consumers across jurisdictional lines. And again, coming back to the, I guess, whack-a-mole type kind of problem in terms of where the jurisdiction extends into space, or which jurisdiction into space for a particular space objects, the complexity of these sorts of issues sort of starts to magnify. Another thing which I think is quite interesting and cool is targeting consumers or advertising to consumers on Earth, but doing it from space. So you think about having a massive billboard in space, for example. So this is termed obtrusive space advertising, and it's called obtrusive for numerous reasons. One of which it would be quite weird, I think, at the first instance to see a massive billboard in space. But also there's issues of, will the billboard block line of sight for telescopes, communication, and all those sorts of activities. So the US prohibits the granting of a launching license related to obtrusive space mining. Russia in principle does as well, but they don't specifically ban obtrusive space mining, obtrusive space advertising. So, there is quite a bit of regulations and law that look to prevent such advertising, but there is still interest in this area. So as an example, Space Marketing was a company that was based in the US in sort of the early to mid 90s. And one activity that they were looking to do was to send a billboard in space that was a mylar sheet that was about a mile wide and a mile high, and it had the Olympic logo on it. And they wanted to send it up there for the Olympics that were in Atlanta in 1996. That didn't get off the ground for financial reasons. So I guess we'll never really know whether or not the various laws and regulations would have prevented it, but it's interesting to think that this isn't a new area of endeavour, I guess. So Start Rocket, they're a new Russian company. They've started sort of midway through last year, and they're planning to send low orbiting satellites into space to form images. So each satellite has its own reflective mirror and acts as its own pixel. So you can send up any number of satellites to form, whatever particular image you want. So it may be that at some point we are going to see Pepsi being advertised through the night sky. Perhaps, but maybe not. So obviously there's certain issues with registered IP rights, designs, trademarks, patents, for example. So what about trade secrets? I mean, that's clearly a pretty useful alternative, I guess, to these other registered rights. And to some extent, trade secrets avoids, and I use that term loosely, the jurisdictional boundary issues of registered IP rights. Obviously, the advantage of trade secrets is you're not disclosing, your technology to your competitor, and the term of protection runs in perpetuity, provided, of course, you can maintain that particular secret. So companies such as SpaceX, they rely on trade secrets to protect a lot of their IP. And, for companies such as SpaceX, where they're kind of doing the beginning to end sort of stages of space exploration and space activities, for companies like that, trade secrets probably do work quite well because you have a bit more of control, I think, over the whole process. But for companies that need to procure, for example, launching services or different services related to whatever activity they're trying to do, that's where I think trade secrets may start to not be as useful for space-related technology. I guess, the other two issues for trade secrets that I'm sure most people listening would be aware of, that once the trade secret is no longer secret, you can't go then back to say, oh, I'll file a patent to protect this for another, 20 years. It just doesn't work that way. There's also the issue of, well, when does a trade secret just become information, and how does that information then travel when you have sort of ex-employees and things like that. So obviously, trade secrets are, I think, would be very useful for space-related technologies. They're not without their faults or issues. And I see one of the biggest issues of using trade secrets to protect IP for space-related technology is in the event of any accident or incidents. So generally speaking, and this isn't true for every single situation, obviously, but generally speaking, once there is some form of accident in relation to space technology, you have a rocket that blows up, 15 seconds after launch, for example, that's followed by an investigation. It may be that during that investigation, confidential information of particular parties have to be disclosed to allow the investigation team to work out the root cause of that particular accident. Partly the reason for this is the fact that to send an object into space, and this comes back to Article 6 of the Outer Space Treaty, as I mentioned earlier on, there has to be some form of insurance, and some of these insurance policies can be quite stringent and can be for large sums of money. So if you had a company that provide launching services, for example, your insurance provider may say, well, we're only going to cover you in the event that we know exactly what you're launching. So then if you're engaging with third parties, you might say, hey, I need you to disclose, how your robot works, for example. There's also no international failure review standard. So each jurisdiction has its own laws and standards for how an investigation takes place. So in Australia, at least, the relevant minister is ultimately responsible. They will typically appoint some form of chief investigator, and whatever information is raised during that investigation should be kept confidential and not disclosed. However, the minister does still have the power to disclose information should they deem it necessary. So although it's probably not likely that, following an accident, there is going to be some form of catastrophic disclosure of IP, it is still potentially there. And, also keep in mind that, these sorts of activities require a lot of capital and are typically incredibly expensive. So, the loss of, some robot, that may be $50 million in itself, but the amount of R&D that took to get there may be, in the hundreds of millions of dollars, for example. And I guess lastly, in relation to these sort of accident incident scenarios, typically there'll be some form of disclosure at some point about what happens. I mean, you think about every time a rocket's gone up and exploded, at some point in time after they've done some investigation, they go, oh, actually, there was a faulty valve and it didn't work because something fell off and hit it, and then it caused, a chain reaction. Or it could be that, the computer program, there was a certain line of code wasn't quite right, which caused, a satellite to change altitude, and then it, bumped into the space station, for example. So those disclosures themselves may, they may be perfectly fine in terms of keeping information confidential, but it could be that, someone who's quite skilled in that particular field may see that and go, actually, if that's the root of the cause, then it has to be operating in this particular way. And, so there could be some form of loss of information there. So in summary, I mean, how is it, what is the best way to protect IP for space-related technology? Well, I think even for clients that we service now, we still have to have a good understanding of the commercial strategy, how they want to exploit their IP for commercial gain. But I think for space-related technology, you have to have a much deeper understanding of that commercial strategy, and that extends into how are you looking to get your launching license, for example. Why are you choosing Australia over other countries? What are the insurance requirements for you to send that particular object into space? Do they say, well, you can only work with certain providers that we've already pre-approved, and all these sorts of things. There's also the International Traffic in Arms Regulation, so ITAR controls. So if an Australian company, for example, was to collaborate with the US company, ITAR controls would come into effect. And so then obviously you've got some form of US legislation regulation that would affect how you then operate, and use your commercial advantage. There's also geographical and geopolitical limitations as to the number of sites around the world where rockets can be launched. So in principle, yes, you could have this Russian problem, the Nigerian problem of, your competitor setting up a subsidiary in another jurisdiction as a way to circumvent, your patent rights, for example. But the reality is that's probably a lot more complex than it appears on face value. For any patented technology that has to be operated from Earth, have the claims linked back to a specific step on Earth. So if you're talking about a satellite, for example, you could say, well, sending a control signal from a control station to the satellite. That control station may be on Earth. It could be in space somewhere. But at least if it's linked to, a jurisdiction on Earth, then it kind of brings it back down, so it's not as out there, I guess. And it's also true for, let's just say you're sending a, robot to go do mining on the moon. You could have, step one, launching the object into space. Step two, start mining, for example. So, it could be that in that particular field, there's only a number of launching states around the world or launching locations. So if you have to launch through those jurisdictions, at least the patents can then capture, not all of it, but at least some of the infringing activity. So I think ultimately any IP strategy that's developed that looks to protect space-related technology has a much more holistic view of how the IP is generated and exploited. So I think it needs to be viewed more in terms of knowledge management and looking at intellectual capital and how that's used, and trying to dovetail it into all those separate sections so that, if a trade secret is lost, for example, or you can't enforce your patent rights because someone's craftily managed to circumvent the jurisdictional issues. If you're looking at IP from a knowledge management point of view, then that loss may not be as significant as it otherwise would be. A few last thoughts is the fact that in space there's going to be new things that we have to think about. So these different scenarios are more patent focused than anything else. But you think about, well, what counts as disclosure in space? What is reasonable trial and experimentation? If you're hiding behind Uranus and no one can ever see it, are you disclosing, or by doing that activity, are you then saying, okay, we're actually going to proceed with trade secrets? What is patentable eligible subject matter is reproducing something that occurs naturally on Earth, let's just say growing a tomato and doing that in space. Is that patentable eligible subject matter? I mean, you think about the state of software patents, for example, and the kind of flux that they're in relation to patent eligibility. I could only imagine that this will probably be an area that will continue to rise in the future. What happens if the claimed invention can only be used after the term has expired? So let's just say you want to do some asteroid mining. The asteroid is 25 years away, or it takes 25 years for your object to get there to start the mining activity, but for whatever reason you have to patent at day one, to secure your rights. Could there ever be changes in patent terms, for example, similar to the pharmaceutical industry in relation to getting regulatory approval? Could that potentially be applied to space-related technology? I guess as well, in principle, there's time dilation due to gravitational differences in space. So those of you who've watched Interstellar, now I can't remember the specific planet, but the planet they landed on that was quite close to Gargantuan, the black hole, 1 hour on Gargantuan was about 20 years back on Earth, for example. So where is the term of a patent calculated from? Is it from where the activity is occurring, or is it from the jurisdiction back on Earth? And will there ever be a harmonized space patent? Given how hard it is to have a harmonized patent system on Earth, I think that's probably something that is so well down into the future that we probably don't even need to think about it for the time being. So that's all that I was going to talk about today. So hopefully it provides a bit of an overview of the interaction of space law and IP laws, and how you can't just use sort of stock standard IP protection strategies for clients, and how you have to think about them kind of differently. So I'll just go and have a look at some of the questions that people have put up. So Sophie said, has there been any litigation cases or contentious matters dealing with issues of inventions or trademarks in space? To my knowledge, no. I think it's important to note that although organizations such as NASA have ultimately been responsible up until about 10 to 15 years ago, they still outsourced quite a lot of their technology. But it was a company A in the US was building a particular component for a rocket. Then that went to NASA, and then NASA ultimately assembled the rocket itself. So there may have been litigation in respect to that sort of technology, but that would be very similar to what occurs for any sort of patent rights now, for example. So I don't think there's been anything specifically related to any infringement activities in space. So I've just got one from Nicola Sheepers. Have any studies been done on the environmental impact of space mining? It seems that could be quite a sensitive impacts of mining on the moon. Yes, that is, I didn't talk about this at all. This is a huge area of, I guess, contention to some extent. So at least from my understanding, and there's probably others who have a better understanding than me on this particular subject, in principle, you're not allowed to sort of start transferring, things like microbial contamination between, say, the moon and Earth. There was a company, I think it may have been an Israeli company, I can't remember off the top of my head. They sent a spacecraft to the moon, and they had some particular type of organism because I think they wanted to see how it affected in space, but it crashed on the moon, essentially contaminating the moon. So yes, in principle, yeah, this is quite a big area. I think that is will have a bit of interest going forth. However, if you think about the vastness of space, if you're mining one asteroid in the asteroid belt, does it matter, but what sort of long-term effects would that actually have? Okay, Erica asked, if a company incorporated in one jurisdiction, say Australia, procures launching from a company incorporated and operating from another jurisdiction, say the US, where will the space object be registered to? Is there a default or is the option to choose? That's a really good question. You can choose. So a lot of joint ventures, for example, may be across different countries and different jurisdictions. It's up to that joint venture to decide where they want to register that particular object. So this is something that I guess has been done, quite extensively now, just through the sheer collaboration and the necessary collaborations you need for these sorts of activities. And I think that is all the questions. So if there's no more, I think we'll cause it to the close. And thank you everybody for listening.
Just thank you very much, Stefan. I just wanted to quickly say to people that there will hopefully be a recording of this coming out and will be shared with all attendees from this. I thought it was a really interesting presentation, and especially as a marketeer myself, looking at advertising on the moon, it kind of refers back to the Hancock movie, I think, where they put the logo on the moon. So it's interesting to see kind of what the implications to that are for me. But really appreciate the presentation. And as Stefan said, if there's any questions, please don't hesitate to get in touch. Cool. All right. Thank you very much, everybody.